My name is Jamie McDonald. I am an attorney with McDonald Law Offices. Our firm represents individuals in consumer bankruptcy cases throughout the entire state of Arizona. Today I'm going to talk about tax refunds when you file a Chapter 7 bankruptcy case. A state or federal tax refund owed to you on the date that your case is filed is property of the bankruptcy estate and must be turned over to the bankruptcy trustee. The bankruptcy trustee will require that you turn over any state or federal tax refund that is owed to you on the date of filing. When the trustee receives those refunds, the trustee will then disperse the funds to your creditors on a pro rata basis. They'll get the money. There are a couple things to look at here regarding tax refunds. First of all, if you have not received and legitimately spent the refund at the time your case is filed, the entire refund must be turned over to the trustee. For example, let's say you file your Chapter 7 bankruptcy on March 1st, 2013. By that time, if you have not already received your 2012 or any prior year state and federal refunds, those refunds will be property of the estate and the entire amount must be turned over to your trustee for distribution to your creditors. The trustee is also entitled to part of a year. For example, let's say you file your Chapter 7 on July 1st, 2013, and let's say you've already filed and received and spent the tax refund for the 2012 tax period. Those refunds are not an issue. You've received and spent them before filing. They're not property of your estate. However, the trustee will be entitled to require that you turn over 6/12 of your 2013 refunds when you receive them in 2014. If you file on July 1st, 6 months of the year has already passed. Therefore, the trustee would be entitled to half of the refund for the 2013 tax period. If you elect to wait to file your bankruptcy until after you've received and legitimately spent the refunds, you must retain receipts as proof of what those refunds were spent on. You're allowed to spend refunds legitimately on such things as attorney's fees for the filing of the bankruptcy. If you own a house with a mortgage on it, you can use those refunds to pay the mortgage. If you own a house and you're living in it and claiming that as a homestead, you can use those refunds on home repairs or improvements. Be sure to keep receipts, however, as proof of what you spent the funds on. If you are renting, you may use the refund for rent. I must give you a word of caution in using refunds on rent, however. If you are going to use the refunds on rent, make sure that you do not prepay the rent to such an extent that the amount you've prepaid exceeds the amount you're allowed to exempt for prepaid rent. If you do so, the trustee can recover those funds and distribute it to your creditors. Make sure you talk to your attorney about prepaying rent before you do so. You can use the refunds for things such as utility payments, electric, water, phone. However, do not pay those bills in advance. For example, if you receive your refund on March 1st and your electric bill is due on March 5th, go ahead and pay it. Just don't pay it in advance. Pay the existing bill. You may use your refund for food items, clothing, vehicle insurance. Be careful on paying vehicle insurance in advance. You don't want to do that, but if you pay your next vehicle insurance bill with those funds, that should be okay. You can use the refunds for gas and maintenance for your vehicle. If your vehicle needed new tires, you can get new tires. If it needs some engine or transmission work, you can do that as well. I must give you a word of caution when spending your refunds, however. Do not spend the refunds in such a way that you're making payments to your creditors that could be considered a preference under the Bankruptcy Code. There are a number of issues involved regarding that, so I'm going to direct you to your attorney. You just want to make sure that you do not create a preference. The trustee can undo that payment, get the money back, and distribute it to your creditors so that you were not successful in doing that. Also, do not pay off a debt such as a vehicle loan in such a way that you will now have non-exempt equity in a vehicle. For example, let's say you own a vehicle worth $8,000. there's a lien on the vehicle, you still owe $3,000 on that lien, and the Arizona exemptions apply, and you're going to use your $5,000 exemption on the vehicle. You would have $5,000 equity in it, the difference between the $8,000 value and the $3,000 you owe. You can exempt the $5,000 equity. There's no problem. You can retain that vehicle. However, if you take your refund and pay down that loan or pay it off, let's say you pay off that loan, now you're going to have a vehicle worth $8,000. There's no lien on it. You can only, let's say you can only exempt $5,000. If this is not a joint case, you can only exempt $5,000. You have $3,000 non-exempt equity in the vehicle. The trustee is going to take the vehicle, sell it, return the $5,000 to you for your exemption, distribute the other $3,000 or whatever the trustee received from the sale to your creditors. So therefore, you want to be very careful on paying something off or down. Talk to your attorney first before you do such a thing. If you have any questions regarding tax refunds in the context of a Chapter 7 bankruptcy, please give us a call, 480-968-3100.